The Fourth Amendment protects against unreasonable searches and seizures. To be considered reasonable, searches and seizures must generally be pursuant to a warrant, but there are exceptions to the warrant requirement. In Washington v. Chrisman, we explore one such exception, namely the plain view doctrine. A university police officer stopped student Carl Overdahl as he was leaving a dormitory carrying a bottle of gin. Because Washington law prohibited persons under 21 from possessing alcohol, and Overdahl appeared underage, the officer arrested Overdahl. He asked to see Overdahl's identification. Having left it in his room, Overdahl asked to retrieve it. Overdahl consented when the officer insisted on accompanying him. Initially, the officer waited in the room's doorway. Overdahl's roommate, Neil Chrisman, was present and grew nervous upon seeing the officer. The officer noticed what he believed to be marijuana and a pipe laying on a desk. After entering the room and confirming that belief, he Mirandized Overdahl and Chrisman, informing them of their rights to remain silent and have an attorney. Both students waived those rights. Chrisman then produced 3 small bags of marijuana, and the students consented to a search of their room. The search revealed more marijuana and lysergic acid diethylamide, or LSD, both of which were illegal. Chrisman was charged with felony possession of both substances. He filed a motion to suppress the drugs as evidence, claiming that the officer engaged in an unreasonable search and seizure, violating the Fourth Amendment. The trial court denied Chrisman's motion, and he was ultimately convicted. The appeals court affirmed, but the Washington Supreme Court reversed, holding that even though Overdahl was under arrest, the officer wasn't entitled to enter the room or seize evidence without a warrant or exigent circumstances. The United States Supreme Court granted cert.